Good morning and welcome to this morning's Knowledge Bank webinar. Today's session is presented by Verity McMahon from Brethertons and Peter Rudd from Easy Lease Extensions, who are going to be talking you through a guide to lease extensions. The webinar is being recorded today and will be available to watch back this afternoon via the News on the Block YouTube channel, as will a copy of the presentations will also be sent to you this afternoon. If you have any questions throughout the webinar, please submit them in the Q&A box at the bottom of your screen, and we will try to get through as many as possible at the end of the webinar. I am now going to hand you over to Verity.
Hello everyone, good morning. So today we'll be going through a guide to lease extensions, and the aim is to give a bit of a whistle-stop tour around the process, some of the things to look out for, and some of the pitfalls that you can potentially fall in or your clients can fall in. We'll mainly be talking about a statutory lease extension today and the process involved in it, but we will briefly be talking at the end another route, a voluntary lease extension available to clients. So I'm Verity. I'm a senior associate at Brethertons Solicitors, and we specialise in leasehold enfranchisement. And I'm today presenting with Peter Rudd, who's a managing director at Easy Lease Extension. He specialises in leasehold enfranchisement valuations. A quick disclaimer, obviously this isn't legal advice and we can't accept any responsibility for any advice that is relied on throughout the webinar. Okay, so we're going to cover a step-by-step guide to the right to extend the lease of a flat under the Leasehold Reform Housing and Urban Development Act 1993, which we'll refer throughout the webinar as the Act. And again, key elements of the claim to be aware of and step-by-step guide when advising your client. So there are qualification elements to have a statutory lease extension. The Act in which this is under is the Leasehold Reform and Urban Development Act 1993, and this entitles all flat owners to a 90-year lease extension in addition to the unexpired term that they've got on the property, and reduce their ground rent to zero. So this is beneficial obviously for those leaseholders that have a short lease or very high ground rent. It's also on the same terms as the current lease. So we normally do this by way of a lease by reference, but there are certain elements that can be varied in the lease extension process. The parties to a lease extension will be the freeholder, which will become the competent landlord. This can sometimes be an immediate landlord if there is a head lease involved. A management company, beware there could be more than one, and obviously the leaseholder. So the leaseholder is entitled, provided the property is a flat, which I know sounds a little bit obvious, but do beware of abnormal situations. Through working through the leasehold sector, there can be flats that look like flats that are defined as coach houses. You know, they could be the use of a flat, but it actually looks like a house. There's all sorts of things. I've had a case not long ago where there were some moorings down in Norfolk where they were defined as flats, but they actually look like little cottages. So just beware, always refer back to the lease. It has to be a long lease, so the original term has to be over 21 years. It can't be anything below that or the leaseholder won't qualify. And this is quite important. The leaseholder has to own the property for a continuous period of 2 years prior to the relevant date. So prior to you serving the notice, which we'll go through in a minute, your client needs to have owned the property for 2 years prior to that. And it goes from the date of registration, not from the date in which they purchased the flat. Also, bearing in mind, if you're dealing with probate, this is another pitfall that people can fall in, is that it goes from the date of the grant of probate. So whoever inherits the property, the executor, can go forward and extend the lease with the same rights as that of the previous owner that has died, but they have to do it within 2 years of the grant of probate. If they do it outside of that time, they're not qualified, and therefore the beneficiary won't be qualified to extend the lease in the same way, and they'll have to wait 2 years. All of this is in return for a payment to the freeholder called a premium, which will need to be assessed by a specialist valuer like Pete, who will go through that in a minute. You'll never qualify for a statutory lease extension if the landlord is a charitable housing trust and the flat is part of the charity's work. So any housing trusts or associations, they can qualify, but just make sure that the flat isn't let out on a charitable basis or a shared ownership lease. Business and commercial leases, again, don't qualify for this process. It's residential only. Now, the first step is hopefully you will know and identify all of the people involved within the lease extension. So your competent landlord, any intermediate landlords, and your management company. However, it sometimes is that you don't know who these people are. They might have gone missing. It might be that they're uncontactable. It might be that they've not served ground rent demands on you for a long time. So you just don't know who they are. It could be that you don't know the service address for a particular landlord. You might know the freeholder, but not the service address for the intermediate landlord. So you need to request some information. So you make sure that your notices get there correctly. And that's under section 41(1) of the Act, and a request for information from an intermediate landlord or any person receiving rent on their behalf. So that could be a managing agent, for instance. They should supply the name and address who owns the freehold and the address for service, and they have to give that within 28 days. Always check ground rent demands though. It's often kept in the very small print and address for service that could be different from the registered office address of either the freeholder or the intermediate landlord. So I'll pass to Pete now, because one of the first steps in your lease extension is to assess how much it's going to pay. Often leaseholders don't want to proceed until they know roughly what they're in for in terms of valuation. So I'll pass to Pete to go through that.
Hi, good morning. Right, as Verity says, I'm Peter Rudd. I'm the Managing Director of Easy Lease Extension. I have a few slides prepared to try and give you an understanding of how the calculations work. As Verity mentions, it's quite important to be aware of how much you're potentially going to have to pay your landlord before you serve your statutory notice, because once served, you are locked into a statutory process, which you're advised to see through to completion. You are able to opt out, you can withdraw from the claim, but there will be costs involved. If you do have to cover the landlord's costs if you decide to withdraw. So as valuers, we have to stick to a specific set of formulas, and they are covered under Schedule 13. So you are recommended to instruct a specialist valuer to ensure that the calculations are correct. Calculations can change from time to time. There can be tribunal cases that will kind of affect the way that the calculation is put together. So it's very important that your valuer is up to date with, say, upper tribunal decisions, first-tier tribunal decisions, just to see what's being decided and taking guidance from those decisions so that you can ensure that your valuations are as accurate as possible. Now, you can't provide a decimal valuation. You can't provide an exact calculation for a lease extension. So the report that you receive will always give you a best and a worst case scenario. So a lower and an upper range that your valuer is advising you should fall within following negotiations over the premium with the landlord. So the valuations can be quite complicated. As Verity mentioned, sometimes you can have multiple landlords, and this can mean there is a potential split of a premium. So you can be dealing with a fairly complicated calculation that is made even more complicated by having to apportion those amounts between two landlords and potentially have to deal with two separate valuers, one for the, say, one for the head lessor and one for the competent landlords. It's also very important to be aware of marriage value. How that can affect the premium. It's also very important to know the unexpired term of your lease. So it's very important to know whether your lease is approaching 80 years, as this can make a significant difference to the premium your landlord is entitled to. So if you wouldn't mind, Verity, can you flip over to the next slide? When calculating the premium, you have to, there are various components that are used, various considerations, and the main ones are the unexpired term of your lease. So the time remaining on your lease has a big impact on the premium you pay, and also the ground rents contained in your lease and whether there are any reviews to that ground rent. So you may have a static ground rent, a fixed ground rent of say £10, and that could be fixed for the entire duration of your lease, meaning when your lease was granted, the £10 had value, and that value will diminish over time with inflation, meaning the £10 on the grant of the lease is going to diminish and depreciate over time. So you may have a larger ground rent. You might have a stepped ground rent of, say, starting at £100 with the typical 99-year lease. Generally, they will step up once every 33 years. There's no set rule, but that's quite a common ground rent review. So you'd have perhaps a ground rent that starts at £100. After 33 years of the term, it will say double to £200. And after another 33 years and for the duration of the term, it will double to £400. And that allows the ground rent to kind of keep pace with inflation. So the leases are written in a way so that the ground rent for savvy landlords, they ensure that their ground rent is not kind of losing value over the term. Another ground rent example you might see is one that is linked to RPI, the retail price index. So if your ground rent is linked to the retail price index, that simply means that you have to check the index at set intervals that are defined within the lease, and you have to adjust and increase the ground rent in line with RPI, effectively inflation. So that ensures that the value of the ground rent to the landlord kind of, it never diminishes. It's keeping pace with inflation over the duration of the lease. And the present lease value needs to be considered. Now, if you have a lease of, say, over 80, 90, 100 years, your present lease value might potentially be roughly the market value of your flat. However, your present lease value, if you have a lease below 80 years, where marriage value is applicable, if your lease is below 80 years, the present lease value may be far below what you would hope to sell it for with an extended lease on the open market. So effectively, the value of your property can be worth far less depending on the term of your lease. Now, if you unfortunately have a lease that has a term below 80 years, marriage value has to be factored into the calculation. And this is very important for leaseholders or tenants to be aware of, because it can literally double the premium overnight. And if they're not aware, a claim that could have been made last week to protect your interest will be completely lost. As once the term falls below 80 years, you can't reverse the clock. There's no going back, and you will be obliged to pay marriage value as part of your premium to your landlord. Can you flick over to the next slide, please, Verity? So what I put together here is just an example of a lease extension calculation without marriage value. I've tried to cram it as best as I can on the screen, so I do hope you can see it. There's probably lots of numbers and figures that I'm going to try to go through to give you an explanation as to how it works and the effects of maybe a lease extension with consideration of marriage value and without. So we're going to use an example here. I'm using an example, a flat with an extended lease value of £250,000. So we're taking an example of a £250,000 flat, and in this example, no marriage value is factored into the calculation. So you'll see a box with the components that we're considering to make up these calculations. You can see the start of the lease, the 1st of January 2005, the expiry of the lease, 31st of December 2103. And the date of valuation, which is today's date, and the original term, which is 99 years. So these four things allow us to calculate the remaining term of the lease. And for this example, the remaining term is 80.16 years. So above 80 years, no marriage value is necessary. Below those two boxes, we have the unimproved lease value, and we're using £250,000. And we also have to make a consideration as to the value to the landlord. And that's quite a simple calculation. You simply uplift the £250,000. This is accepted by tribunals that the value to the freeholder is generally 1% more. So we've got £250,000 and £252,000, 525 being the value to the landlord. Here we have a capitalisation rate, effectively a yield, and we have a deferment rate, and that is set at 5% in a kind of a landmark tribunal case known as Sportelli. This deferment rate, it can change. There are some certain exceptions, but generally you would use a deferment rate of 5% for most lease extensions. Now, there are two considerations that we're making with this calculation. And the first is the loss of ground rent. So when you extend your lease under statute, as a leaseholder, providing you qualify, you're entitled to a 90-year extension on top of your unexpired term. And your ground rent is basically goes down to a peppercorn. A peppercorn is the consideration. So your ground rent has gone from, say, this example here, £100 per year, going up to 200 and then 400. Once you've extended your lease, you'll be liable to pay one peppercorn per year. And that is under contract law. It is literally a peppercorn. If the landlord chose to demand a peppercorn from you, they could, but the value of that peppercorn is effectively worthless, so they'll never demand it. So it just ensures that there is a consideration to make the contract valid. Now, the ground rent here, as I said, it's a stepped ground rent doubling every 33 years. Well, we've only got 14.17 years left in this example of the £100 annual rent, and that's going to step up to £200 in the next 14.17 years. Now, a stepped rent, we're applying a capitalization rate to allow us to work out, say, the present day value, what an investor might pay to receive that return. For a stepped rent, anywhere between maybe 6 to 6.5% could be agreed with the landlord, providing they're being reasonable. And this produces a loss in ground rent to the landlord of £2,464.62. So that is considered the present day value of that ground rent, and that is what must be paid to the landlord effectively. So if they choose, they can reinvest that in a similar investment. Now, the next consideration is the loss on reversion. And the loss on reversion is basically the landlord, once you make your claim to extend your lease, you are preventing the landlord from taking the property into possession in the next 80.16 years. So as the landlord is not able to take the flat back into possession, they are going to suffer a loss. So in this example, we have to calculate the value to the freeholder. So we will take the freehold vacant possession value, and that is deferred over the term of the lease by 5%. Now, the value in this example here would be £5,055.20 to the landlord. And in addition to that, there is a further value as they are extending your lease. So you have the 90-year extension, which is what you're entitled to under statute. 170 years is considering the 90-year extension, and the value of the same asset on 170.16 years deferred at 5% would be £62.62. That is deducted from the landlord's present interest of 80.16 years. Now, these figures are rounded for a bit of simplicity, but if you calculate those two figures together, so you've got your ground rent loss and you have your loss on reversion, those two figures combined are £7,457.20, but quite typically you would round the figures to make negotiations easier. So in this example, the premium is £7,500, and that is effectively what your landlord would be entitled to for a property with this unexpired term and a value of £250,000 with these rents. So that's the first example without marriage value, and I'm going to lead on to an example that includes marriage value for the precise same lease with a term granted 1 year earlier. So Verity, if you wouldn't mind flicking over to the next slide.
Yeah, you're on.
So here we have a slightly longer calculation, and effectively the first two sections of the calculation, the loss in rent and the loss on reversion, are effectively the same. There are some small differences because this lease was granted in 2004 as opposed to 2005, meaning its remaining term or unexpired term is now 79 years. So we're into the realms of marriage value now, and this does make the calculation a lot more complicated. Now, when you are calculating marriage value, you have to establish the present lease value, and it's not going to be worth the same as its extended lease value. It's worth far less. If you try to place a property on the open market, there are going to be issues with achieving lending. You're often relying on a cash buyer, so they're going to pay a lot less for the property because they understand the implications of the lease extension and how much they're going to have to pay the landlords. they won't just make considerations on the premium when making offers for a short lease flat. Quite often they're going to consider their costs. So their own professional cost to extend their lease could well exceed maybe £2,500. And in addition to that, under legislation, the leaseholder is responsible for paying the landlord's costs. So a savvy cash investor trying to buy a short lease property is probably going to consider all of that and offer the lowest amount possible for that short lease property. So there is definitely a difference between a flat that has an extended lease and a short lease. So we're using the same flat, a £250,000 flat, but the only difference is this is a year later. So, or a lease granted 1 year before, meaning it's got a lower term and we are within the realms of marriage value. So in this example, we've got the same two calculations. You've got your loss in rent and your loss on your reversion. Now, in addition to this, we have to calculate the marriage value. Now, this calculation, we have to consider the value under the new lease. So when the lease is extended and the term is taken above 80 years, when the term is taken above 80, when the lease is extended and the term is taken above 80 years, the property is going to go back to its full potential value of, say, £250,000. So the value under the new lease is £250,000. We also need to look at the value of the freeholder's new interest. So by granting the lease extension, the freeholder is entitled to 65.75. So that is their new interest once the lease has been extended. Now, the total of those two figures, again rounded, but £250,000, £250,066. Now, what we're doing here, the value of the existing lease, we're calculating how much the lease is worth with 79 years unexpired, and we apply relativity to the value of the property, so we can calculate the short lease value. Now, there are two ways to do that. First of all, as a valuer, you should look to see if you can establish market relativity. Tribunals do prefer market relativity, and market relativity can be established by looking for local comparable sales and seeing whether you can identify whether any leases have already been sold on a short term. So once you've established, if you can find, they're very hard to find, it's very difficult to establish market relativity, but if you are able to find comparable examples of short lease flats and then very similar flats being sold on a long lease, you can then calculate the difference yourself and establish market relativity, because you have evidence of flats being sold on a long lease and flats being sold on a short lease, so you can calculate the percentage relativity yourself. That's preferred by tribunals, but as mentioned, it could be very difficult to establish market relativity because often the evidence just isn't there. The sales you should be considering generally should be within a year or two, so it's quite hard to find a wealth of evidence to confirm market relativity. So where there is no market relativity, we refer to the graphs of relativity. So there are commonly used graphs of relativity. They're all expressed as a percentage. And what this allows us to do is take the unexpired term of a lease and apply a percentage to the freehold vacant possession value in order to calculate the short lease value. So in this example, we're using relativity of 89.52%. So 89.52% is applied to the freehold vacant possession value of the lease. And the difference, the value of the existing lease after applying the 89.52%, the value of our existing lease, which you'll see down at the bottom, section 3, marriage value, bottom left corner, is £226,061. Now, in addition to that, we are taking the value of the freeholder's existing interest, the existing interest being the 65.75 and their loss in ground rent. And what you'll see over to the right-hand side, the two totals, we have £250,066, £233,885. Now, the difference between those two figures is £16,181. And under legislation, the landlord is entitled to 50% of that. So what you can see here is a lease that would have been extended with an 80-year term, that being previous example, 7,500, just a year later, the same lease will cost £15,800. So it's an example to show the importance of being aware of your unexpired term, when it's going to hit 80 years, and trying to ensure that you put provisions in place to extend your lease before you get to the 80-year mark. Otherwise, you will pay the landlords potentially double what you would have paid the previous year.
Great. So I think that demonstrates as to why you definitely need a specialist valuer involved. It's a very complex calculation that valuers do in preparation for service of the Section 42 notice. So once we've got our range that Peter's just demonstrated previously, and we know what our opening offer will be to our freeholder, the lawyers will draft the Section 42 notice of claim. Now, there's no prescribed form for this, but it must be in writing and it must include certain things, such as the leaseholder's full name, the details of the landlord, any intermediate landlord, management companies, details of the lease, counter notice deadline obviously needs to go in there. We give the competent landlord 2 months in which to respond. Be aware of postage. Make sure that you leave enough time when serving these notices. It's a common pitfall to fall down. Don't just date it 2 months, leave it 2 months and a week to allow time for it to get there, or 2 months and 2 weeks. You serve all landlords and third parties. If you don't serve all landlords, your notice can be deemed invalid and you have to start again. You serve this on the landlord's registered office addresses, check the lease, check the title, check ground rent demands. Ground rent demands are very important because often it can be kept in the very fine print right at the bottom of the demand, a separate address for service of notices of these kinds. Before serving the notice, it's important to get a deposit ready from your client. So the landlord is entitled, once the notice is served, to a 10% deposit of the premium that you have offered. You have to pay this within 14 days. So it's always wise to get that on account before the notice goes. And also, if you are signing the notice on behalf of your clients, on behalf of the leaseholders, make sure you get written authority to sign this. Freeholders' solicitors will often ask for proof that you have authority to sign. And obviously, if you don't, it can be deemed invalid. Service is all kept under Section 99(1). It must be in writing and it may be sent by post. Emails, I wouldn't risk it unless it's pre-agreed. It's not a deemed valid way of serving a notice. Always serve by post. Always get proof of service. Send this by special, courier, anything with proof, basically. And always send originals of the signed notices, not copies. Again, that can invalidate the notice. Caledine and Smith, the burden lies with the sender, so you do have to prove this is properly posted. Again, receipts, personal service, make sure that's really important, because often the first thing that the freeholder solicitor will ask for is proof of valid service. Once this has been served, the same day, register a UN1, a unilateral notice against the freehold title at the land registry. This will protect the notice of claim if it is, for whatever reason, the freehold title is transferred during the period after the notice is served. If that's not on there, it's not protected. I'll go on more to assignment later on in the webinar, but that you can assign the benefits of a notice of claim to a incoming buyer. Once the notice of claim has been served and hopefully validly served, there are various things that your landlord can request between the Section 42 notice going and their response in the Section 45 counter notice. They can request a payment of deposit, which I've just touched on. That has to be paid within 14 days, and it's 10% of the premium, or a minimum of £250. Get this on account. If it is, for whatever reason, the lease extension is withdrawn or pulled out of, the freeholder's solicitor and the freeholder will use this against their own costs. So the deposit can be a return, but always less costs. And obviously the deposit will be taken from the premium agreed at the end of the process. Another common request is a request to deduce title, which is essentially prove the ownership of and prove that your client has the right to request a lease extension, so the 2-year ownership, and check obviously that the people that are claiming the lease extension are those registered at the land registry. That has to be provided within 21 days, and our top tip there is to ensure that on the day of service you get fresh office copy entries from the land registry, so there's no doubt in who was the person on the day of service who owned the property. Another common one is a request for inspection. The freeholder, like the leaseholder, will also instruct a valuer like Pete. They will often want to come and inspect the property to assess the premium figure put into the Section 42 notice, so they can assess and put forward a counter offer, not office. As well, proof of authority for signing, again, get your written authority, and evidence for service on any third parties. So just be careful, management companies, sometimes they're not always in the land registry office copy entries as third parties. Always check your lease, that there's any management companies involved, and check that they're always served. There's no sanction for any of the non-compliance of any of these requests, but obviously your landlord, for instance, if you didn't send over the deposit within the 14-day period, your landlord can serve a default notice under Section 92 and ultimately apply the county court to get that from you. That would probably be in the case where it's very high value premiums. So once our counter notice is, once our Section 42 notice is served, the landlord will respond within the deadline that you have specified within your Section 42 notice. If they don't respond by way of post, the same way that we did, in that time, they're deemed to have accepted the offer that you have made and put forward on behalf of your client. That's very rare. You often find that the Section 42 notices are, Section 45 notices, sorry, are served, but you know, it's just a point to note. These will either admit or reject the claim. Hopefully they will admit it. They will only reject it if it is that it's invalid service or you haven't provided any evidence such as deducing title. They may serve it without prejudice to that. It will state within the Section 45 counter notice any all of the proposals that they accept and all of the proposals that they reject. It will often accept matters like extending your lease for 90 years and the ground rent being reduced to a peppercorn because they're under statute. It will often reject the premium payable because they often want obviously the higher end of the valuation and we want the lower. And it might reject some terms if you're trying to vary any terms within the notice of the lease. If they are rejecting any, they have to make counter proposals, so they can't just reject and not come back with any counter proposals. The key date once your counter notice has been served is 6 months from the date of this. Now, this is a key date in the enfranchisement world. If it is that this is missed, it's technically deemed withdrawn. It can have quite severe consequences on the leaseholder because the whole claim's lost. They'll have to start again, and they can't do that for a further 12 months from the date of deemed withdrawal. So it is vital that these dates are diarised in every diary possible, and obviously not missed. You can apply to the first tier tribunal within 2 months after the counter notice has been served, but often there is a period of 6 months of negotiations between both the solicitors and the valuers involved for both parties. Be aware as well, if it is that there are any intermediate landlords involved or head lessors, they can serve a notice of separate representation, which means they will have their own set of solicitors and their own set of valuers and may negotiate separately. So it might turn from 2 parties involved to 3 parties involved, all with their own representation. And once we've done that, it's on to negotiations. So Pete will briefly take you through premium negotiations and how that is settled.
Okay, so as Verity says, when the landlord returns the Section 45 counter notice, often they will reject, they'll not reject your claim entirely, but they'll reject the offers made. So as I previously mentioned, when providing a report to your client, they have a range. We'll give you an example. I may say the premium is going to be between, say, £12,000 to £14,000 as an example. Now, as well as that, an offer premium would have been calculated as well. So it's quite likely and very typical that when you make your initial offer to the landlord, you will have put a slightly understated premium in. So when they respond via Section 45, they will often reject the understated premium you have offered, and they'll propose generally a much higher premium that is quite often far outside of a range that I would have calculated or predicted for you. So the landlord will reject the offer premium, and quite often, say in this example, if the premium is going to be between £12,000 to £14,000, they might come back and say we want £20,000. So the first thing you need to establish is whether the negotiations are going to be cost effective for you. If they've come back and said we'll accept £14,200, it might not necessarily be worth paying for extensive and technical negotiations, because it possibly won't be cost effective. So if the landlord has a reasonable expectation in their counter notices, which is not very often, sometimes it can be best that you just accept the premium. But more often than not, they will shoot for the stars in terms of their premium proposal, and they'll be thousands of pounds above the realistic range. So if that is the case, you would instruct your valuer to negotiate that premium on your behalf. And the valuer will make contact with the landlord's valuer. So typically, if you're negotiating things regularly, you probably know lots of valuers. You may have dealt with them before. Sometimes you'll come across new faces. But you should first establish contact with the landlord's valuer to confirm their instructions. And they will often delay. It might take them a while to come back, but eventually at some point they should confirm their instructions. And once they have, you can then exchange your initial calculations, so your premium schedules, and you exchange them on a without prejudice basis, so they can't be used if a potential tribunal comes up. So the calculations are exchanged, and the negotiations aren't particularly the premium amounts. You're actually adjusting the components. So in the valuation example we went through, in that example, I used a £250,000 extended lease value. The landlord may have greater expectations. They may believe the flat's worth £300,000, and that will, of course, affect the premium. It will be a much higher premium. They might tweak the capitalisation rate of the ground rent, which resulting in a higher return for the loss in ground rent. They may have different expectations on the relativity that they're applying. So they may try to put in a lower relativity, which will make the marriage value larger. So once your calculations are exchanged, you can then analyze the landlord's valuer's calculations, and you can make suggestions to adjust those components to bring them down to a more realistic level. So as I said, in an example, if they said, well, we think the flat's worth £300,000, you would then be expected to provide some form of evidence, a market comparison, to that landlord to justify why you're using your £250,000 value. If you have a disagreement on the capitalisation rate, potentially the deferment rate, although that's not very often, you would then refer to case law to back up your report and the components that you've used. So you might rely on a particular tribunal case or an upper tribunal decision and say, well, this has been decided in upper tribunal, therefore we'd expect the landlord to obviously take the guidance from the upper tribunal so that we can resolve and agree on a reasonable premium. So as Verity says, when the counter notice is returned, you have 6 months to agree something called the terms of acquisition, and the premium is one part of that. So in an ideal world, and more often than not, the valuers will be able to agree a premium. And when that premium is agreed, your valuer will come back to you, advise you of the premium, and ask for your instructions for that to be accepted on your behalf. And you'll simply go back to the valuer, this time not without prejudice. You can go back in open correspondence to advise them that the premium is agreed. Now, it does happen. Landlords sometimes can have very large expectations, and this can affect leaseholders. So if you're unable to agree a reasonable premium with the landlord, you do have recourse, and you are able to make an application to the first tier tribunal. Your application is made, and effectively what you're doing is you are asking the tribunal to independently determine the premium based on both sides' evidence. Now, once your application is made, What that's actually doing is it's extending the time that you have to negotiate. So once your application is made, you cannot run out of time. Your 6 months, you will not lose, or your claim will not be deemed withdrawn after 6 months of the counter notice being served. So there can be a number of reasons. Quite often, when you make an application to the first tier tribunal, you don't actually have any desire to go to tribunal, but it will extend your time which you have to negotiate the premium or agree the remaining terms of acquisition. And ideally, you would hope to get that agreed before any tribunal date. Again, if the landlord is being difficult, the tribunal will eventually, after the application has been made, they will hand down a set of directions, and those directions will basically instruct the valuers and the solicitors to carry out certain tasks by specific deadlines. So they may say on the 1st of December, the valuers must meet to try to resolve and agree the premium, or by the 5th of January, both valuers must submit expert witness reports. So the tribunal will lay down a set of directions. And when that happens, if the landlord is being difficult, more often than not, that will give them a little bit of a kick that's needed, because they will actually start incurring cost at this point, and it can be cost effective to make that application, put further pressure on the landlord in order to get the premium down to a more reasonable level. So applications can be made, but it is very rare that you'd actually go to a hearing. If it's a very low premium, more often than not, you can get it agreed. If you have a high value flat with a very low lease, and we could potentially be talking of premiums of hundreds of thousands of pounds that are owed, those type of cases are probably more typical to go to a tribunal, as the slightest tweak in one of those calculations can mean the difference of £5,000 to £10,000. So in that case, it can be effective, but generally most are resolved without the need for actually attending the hearing.
Great. So once, it's worth noting in that period as well, the 6-month period, obviously your valuer, as Peter's mentioned, will be negotiating the premium, but also the lawyers will be also negotiating the lease terms. So essentially the new lease that will be in place. And together, agreement of them both mark the terms of acquisition. You have to be careful with the dates. They both the premium and both the lease terms have to be agreed within the 6-month negotiation period after the date of the counter notice. Always note what is agreed within the counter notice. It could be that they haven't disputed the lease terms and it's only the premium negotiation in dispute. Therefore, the date that the valuers agree will be the terms of acquisition, and vice versa. It could be, that the premium is agreed months, a month in, and it is the lease terms that are taking a while to negotiate. The lease terms that have been disputed within the counter notice, once they're agreed, that will mark the terms of acquisition. Form of the lease doesn't count. So it's essentially the lease terms that have been offered and counter offered within the notice. If nothing's been said about it, or if they're just all accepted, it doesn't matter if you've had a draft lease or not. It will mark terms of acquisition agreed once the premium's agreed. If they're not agreed within the 6 months, as Peter mentioned, a protective FTT application needs to be made. It's vital that that is made. If it is the negotiations are dragging, always make the application to protect your client's claim. Otherwise, it's deemed withdrawn, and those consequences that I mentioned earlier for your client will happen. Once everything is agreed, the terms of acquisition, so both the premium and the lease term, that marks another key date within the lease extension process of 4 months in which to complete. Either party can apply to the county court within 2 months after the terms of acquisition are agreed, to enforce completion, essentially. But usually what happens is terms are agreed, and then a completion date will be agreed within that 4-month period. And that will allow time for the clients to sign. It will allow time for withdrawal of funds, etc., etc. Once we are hopefully in a position to complete, there are a few things that I would suggest that are checked before you go through and complete. The solvency of the landlord. Obviously, if it's a company, just do a company's house search on the you know, the date of completion a few days before completion as well, to check that they are still solvent, you know, nothing's happened, and they have the right to obviously grant the lease extension. Any requisitions that you've got with the landlord, such as if there's any restrictions on the freehold title, if they've got a mortgage held on the freehold title, the consent from them. An OS2, I've put if required because you lodge a unilateral notice which actually protects your client's claim. But you know, if you want to do a priority search and check that nothing's changed on the freehold title, it's always worth doing. And obviously, if the leaseholders are holding the property jointly, make sure you've got instructions as to how this is going to be held at the land registry, so you can fill the appropriate section of the lease in. The tenant will pay on completion the premium. Any arrears of service charge and ground rent will often be recouped on completion. So it's worth making sure your client is aware of that throughout the process. You know, if they are an aged debtor, you know, they need to be aware that they've got to pay that back. Reasonable Section 60 costs payable to the landlord. Now, once a claim is served, a Section 42 notice is served, the leaseholder that has served that becomes responsible for the landlord's reasonable legal and valuation costs. So as well as paying their own, they will also have to pay theirs. Now, these have to be reasonable. There are plenty of FTT applications for cost order. So, you know, there's plenty of precedents out there. Solicitors will know what is reasonable and will be able to advise their clients as such. After we've completed, the normal registration goes off to the land registry. So with an AP1, as we all know, probably in the industry, there's a massive backlog at the land registry. So it's taking probably about 18 months to 2 years at the moment, I think, to get that registered. And there's no lender consent required. So if the leaseholder has a mortgage secured over the property, we don't have to get their consent in a statutory lease extension because the Act overreaches that. And if it is that terms aren't agreed, I will go through the two options that leaseholders have got. So this is a first tier tribunal application will need to be made within 6 months of the counter notice. You make sure you're applying to the correct tribunal. They're scattered all across the country. Make sure that they've got the jurisdiction to hear it. The FTT application fee of £100 is now payable by BACS, and the FTT will accept emailed applications if it is that you need to do a last minute one. If it is that you're acting for multiple leaseholders on a block, there's multiple residents doing their lease extensions all at the same time, there can be multiple applications and you can ask the FTT to consolidate them into one hearing. You can apply for both singly the premium to be determined or singly the terms of the lease to be determined, or both. It could be that you've already agreed the terms of the lease and it's just the premium in dispute. So it's, you mark on the application that you only need the tribunal to make a decision on the premium. Always copy in of the parties. If it is that you're sending it via email, make sure the freeholder's solicitor and valuer are copied in, and any intermediate landlords are copied in. Or if it is that you're sending it via post, make sure they've had a copy of the application. As Pete mentioned, once the FTT have the application, they will issue directions, often to push negotiations through. They will set dates in which these things need to be done by, such as exchanging valuation, providing a draft lease, etc. Costs for a first tier tribunal are not recoverable. So it could be that your freeholder is not responding. Just because they're not responding and maybe being a bit unreasonable, it doesn't mean that your costs can be recovered on this, unfortunately. However, each party is responsible for their own costs relating to the first tier tribunal. So your freeholder will have to put their hand in their own pocket at this point, meaning, as Pete mentioned, normally it kind of jolts them into settling the lease extension. If it is the terms of acquisition are agreed, so both your premium and your lease terms, but completion doesn't take place within the 4 months from this being agreed, then we also have to make an application to the county court for a vesting order. This again is a date that you can't miss. If it is that it is missed, it will be deemed withdrawn right at the last moment, which will be disastrous. So it's vital that that is protected. Similar to the FTT, the court fee is paid via BACS and it has to be served on all parties. Now, the difference between the county court and the FTT, costs can be recoverable from the county court dependent on the circumstances. So for instance, if your freeholder has missed the counter notice deadline altogether and are just completely non-respondent, you can recover the costs for the county court application and the solicitor's cost for that and that will be taken from the premium that's paid into court. If completion doesn't take place after an application, a further hearing may be required. And usually the court grants an order and all the terms are sat in there, including all the terms of the new lease. If it is the freeholder doesn't sign after that, the court will then eventually sign the lease on behalf of the landlord and will grant an order which he sent to the land registry. Now, very briefly, you can assign notice of claims right at the beginning. So if, for instance, there is a sale involved, the benefit of a claim can be assigned to an incoming buyer. If this isn't done and the lease extension is being done as part of a sale, so for instance, the seller who has the right to extend their lease because they've owned the property for 2 years serves the notice but does not formally assign that to the buyer, then the buyer will then have to wait for a further 2 years from the date of the registration of the new purchase. That won't be valid otherwise. So it's vital, and it can come in. It's a really useful trick if it is that you've got a sale involved. You can't assign later; it must be done simultaneously, and there's a bit of case law there if you'd like to look it up regarding that. But yeah, that's ideal if it is that you've got a sale that needs to go through and it's quite a high pressured sale. I think, Pete, you were going to go through this. So this is the other option opposed to a statutory lease extension, and it's a lease extension by way of agreement. So we just wanted to add this in so you realise there's another option.
Yeah, we would advise most clients to go down the statutory path. If you have a very good relationship with your landlord, if you've never had any problems with them and you think they may actually provide you with a reasonable offer, a voluntary lease extension can be acceptable. The problem with the voluntary lease extension is a lot of landlords will try to maximize the premium, potentially retain any ground rents, which would obviously become a peppercorn if you go down the statutory path. And you have no recourse. You don't have the protection of the Act if things don't go as planned. So if you're going to, in some instances, the landlord may approach you and offer a lease extension. It's not unknown. Sometimes landlords will write to their leaseholders and say, we will give you a voluntary lease extension. You do need to be incredibly careful what you're signing into, because there is no protection under the 93 Act. So fortunately, I will move on to some reforms shortly, but fortunately we had a ground rent bill 2022 last year. So previously, a lot of landlords would offer a slightly discounted premium, which can be quite something a leaseholder is going to probably focus more on. So, for example, your valuer might say, right, the premium costs £20,000, but the freeholder may have said, well, we'll give it to you for £16,000. Just let us keep a £200 a year ground rent linked to RPI. And what would happen is they'd have a very small discount on premium and potentially a £50,000, £60,000 liability over the course of the lease, which isn't apparent. So that's been fixed, and now the landlords are not able to increase your ground rent, but they can request that they retain a current ground rent. So if you did have an RPI ground rent and you were going to extend informally, it's quite likely the landlord would want to retain that, and they'd probably give you quite a good discount. What you need to be careful of is, are you allowing them to keep a rent that's going to affect the saleability of your property in the future? Mortgage providers are very risk averse, and they don't like taking on ground rents that are considered onerous, basically. And there are a couple of limitations for that. You can say if your ground rent exceeds £250 if you're outside of London, or if it exceeds £1,000 and you're inside of London, it is considered onerous, and you may face complications purchasing a property if it has an onerous ground rent. In addition to that, if the ground rent exceeds 0.1% of the capital value of your property, it's also considered onerous, and that can also cause complications. So whilst we would always recommend you go down the statutory route as you have protection, it does take quite a long time. You at least have protection of the Act. And if things don't go your way, and if the landlord's becoming difficult, you have recourse. Whereas the voluntary lease extension, there is no recourse. Unfortunately, the time that you can potentially spend negotiating with the landlords, the lease is still deteriorating. So you're effectively dealing with a constantly moving target, and the landlord may accept a premium one day and then 2 weeks later say, well, it's increased. So you've got no fixed date of valuation. The lease is constantly diminishing. And in addition to that, the landlord could potentially kind of include terms within the lease that are not favourable to you, that can come back and sting you later down the line. So there is a voluntary lease extension option, but you have to be very confident that you have a good relationship with your landlord and they're not out to get the upper hand over you. So that's something to be very, very careful of, and it's always best to get in touch with the valuer if an offer has been made, and obviously a solicitor if the terms of the lease are going to be changed, just to ensure that that's not going to come back and bite you later down the line.
We've also popped on that slide, you may manage or be part of a block that has already, the leaseholders have already acquired the freehold. That's quite a usual situation, but what they've done, they've acquired the freehold but not extended their leases. So in that case, the company that has acquired the freehold, that the leaseholders are all members of, we often suggest that they grant themselves 999-year leases, reduced all to a peppercorn, and have a full lease review to get out any nasties within the lease. They can obviously do that themselves because they own the freehold. So it's just worth looking out for if you manage any blocks or anything like that, and you notice that there's short leases, but they've already acquired the freehold.
Right, and then going on to the reforms, there are upcoming reforms, and as I said, there was a change to the ground rent bill last year. So there are incoming reforms, and we can't say when these are going to become law. It's going to be a very long process until these actually become law, but there is a King's speech on the 7th of November that you might like to listen to, where this will be covered. So effectively, what is happening at the moment is the government are trying to make the process easier and fairer for leaseholders. It is at the moment heavily weighted in the landlord's favour. The legislation and the leases are all weighted in the landlord's favour. The leaseholder will have to pay all of the landlord's costs and practically cover everything to extend their lease. So the idea behind this is to make the process easier for leaseholders and try to kind of regulate the way the valuations work. So as I've mentioned with the negotiations, I have files on my desk that I've been negotiating for say 8 months to 10 months, even upwards of a year. And this is often because the landlord may be very difficult in their premium expectation, and you have to run through the application to the first tier tribunal, and these things can take an awfully long time. So they're trying to regiment the rates that are being used. So whilst we have statutory formulas, valuers can spend months and months arguing over the rates or the components that are used within those statutory calculations. So the idea is to simplify and effectively make it cheaper for leaseholders. Probably the biggest topic of the change in reform is the government have announced they're going to abolish marriage value. Now, as you've seen by the previous example, marriage value can effectively double your premium overnight if you go from 80 years down to 79.99. Now, the government have said they're going to abolish marriage value. We don't know precisely what's going to happen, but it is possibly considered that they will replace that with some form of equivalent compensation. There are billions of pounds tied up in, say, pension investments all over the country. So if marriage value is removed, effectively the value of a private investor's portfolio could diminish by millions of pounds, potentially billions of pounds. And they may then potentially go on to sue the government under Article 1 of the Human Rights Act. So they do have to be careful, and removing marriage value may have some knock-on consequences. So although they're saying they're going to remove marriage value, it's a bit risky to sit and wait to see whether they do. So for example, if you have an 82-year lease, and you think, right, I'll wait a few years to see whether they actually do abolish marriage value, at that point, marriage value doesn't affect you. So it's worthwhile extending your lease at that point, because that's going to make no difference. Perhaps if you have a lease of, say, 60 years, although your premium is aggressively rising, but because of marriage value, effectively the premium is changing every day. Although that's rising, sometimes it might be worthwhile. So people might want to wait an extra year. If their premium's only going to go up by maybe £1,000 in a year, they might want to wait. I personally think it's very important just to extend as soon as you can, because waiting around and not extending, waiting around to see whether marriage value is going to be removed, if it is removed and replaced with an equivalent compensation, you may practically end up paying about the same amount. So it's risky to wait, and it's disappointing for us. We can't tell you when these things will become law, but it is on the horizon, and the government have said they're going to remove it. I personally think they'll probably replace it with some form of equivalent compensation. Another consideration, I mentioned the kind of the fixed deferment rate that we use to calculate the loss on reversion. It's potentially considered that they might adjust that downwards to a lower rate, which would allow them a higher compensation. Now, the problem there is that could potentially affect leaseholders that have unexpired terms above 80 years, because that would mean they'd actually pay more for a lease extension. So it might potentially kind of balance the loss in the marriage value for those leases below 80 years, but for the ones above, if the deferment rate is adjusted downwards, it could potentially increase their premiums. And I'm sure all of these things will be considered, but it's just important to keep in mind there is reform on the horizon. We are just unsure when that's going to go, when that's going to become law. But as I said, there is a speech on the 7th of November, the King's speech, and I'm sure lots will be covered. So that would probably be quite interesting to watch, I expect. I think that probably covers practically everything, unless there's anything you wanted to mention, Verity, about the incoming reforms at all. One other thing is you're entitled to a 90-year extension now, but the reform has stated that you will be entitled to a 990-year extension as opposed to the current 90. So there are all things to consider. And effectively, even if you did extend your lease now, and you got the benefit of the 90 years, if and when that reform comes in, you could still technically extend your lease and benefit from the 990-year extension. So that would still be an option.
Okay, I think that's all from us, Vicky. I don't know if there's any questions.
Hi guys, yeah, there's got a couple of questions. So the first one, I think you slightly touched on this, Verity, a couple of slides ago. But it says, what about voluntary lease extensions in RMCs, where the leaseholders are also the freeholder and all agree for 999 years?
That's a perfect situation, really. So if it is that they want to do that, what normally happens is it's always, we deal with a lot of blocks that tend to instruct us on a bulk basis, which means you can discount fees and there's a saving for leaseholders throughout. Normally, you'd extend the lease, you'd remove the ground rent within that because you wouldn't pay ground rent to yourselves, essentially. And it would be for a 999-year lease. A solicitor would do a full review of the lease and agree a precedent lease, normally with the board of directors on the RMC. And then that will be filtered to all of the leaseholders that have decided to participate in the lease extension. So it can be done as quite a big project and done quite, sleekly, really, to get all the leases the same throughout the development on an extended basis.
Okay, I hope that answers your question. There's one more that says, are there any specific things to watch out for when dealing with a local authority as a landlord?
I think local authorities are really, I have had one difficult local authority that I've dealt with recently, but if you have a local authority landlord, generally it's the ideal circumstance. The local authority, they just want the value of the lease extension premium, so they will put together a fair calculation. Generally, you'll still have to go through the statutory process. I think there are some local authorities that do offer a voluntary option. If that is the case, it's very unlikely they're going to try to inflate the premium to their own gain. So when you're dealing with a local authority landlord, I would say from Verity's perspective, she's probably the draft leases are in a standard format, so they're not going to try to put something in to trip you up later down the line.
No, I think local authorities tend to be, mean, touch wood, one of the nicer freeholders that you can have rather than a big corporation somewhere. You know, you have to look out for the same things essentially. It could be that I've noticed, and I don't know if you've noticed a bit more, that local authorities are often now insisting on statutory lease extensions rather than offering voluntary. So it could be that, you know, you have a tenant in a development that wants a lease extension, that's approached the landlord, but they've replied saying you need to serve a Section 42 notice. That is them indicating that they want to go down the statutory route and won't basically entertain a voluntary lease extension. It's not all local authorities are like that, but I am noticing it more and more in the London boroughs especially.
When it comes to the premium as well with the local authority, as they said, they only want something fair. I deal with quite a lot of local authority cases on behalf of leasehold clients, so I don't act for local authority, but I do act against them quite often. And I find you can almost strip out an entire process of the lease extension if you just make a reasonable offer. So as I said previously, if you're dealing with a big corporation, the firm of freehold investors, they want the best return on their investment. With the local authority, they'll follow the same process. However, if you just make, again, same example, if I said the premium's worth £12,000 to £14,000, if you offered them 12 to 13 perhaps, they might just accept it. So when you get that counter notice back, instead of a rejection and a counter premium proposal that's much higher, they may actually just accept the premium straight away, which means you can move forward immediately, and that takes out any negotiation fees, and it just strips out a part of the process, and you can streamline and probably arrive at completion far sooner than you would if you was dealing with a more commercially minded landlord.
Okay, there's just one more which I think was off the back of the previous question, which says, what about CGT payable by the freeholder in an RMC situation?
Yeah, it can get complicated. So if it is that you've left it, you know, so we often have blocks that come to us that haven't extended their leases promptly after they acquired the freehold, meaning there is capital gains tax, could be capital gains tax liability on the increase between the premium they paid when they acquired the freehold and the value now, essentially. We have tax specialists that we can refer to in those situations, but we often incorporate a indemnity clause within the leases that we draft for RMCs, which will indemnify the company, so the RMC itself. But in terms of the individuals, we often recommend getting tax advice because everyone is different, and also we can recommend specialists that can help that. Solicitors are a bit limited to obviously the advice that they can give when it comes to tax, but they have contacts that can assist.
Okay, I think that's it. So thank you both very much for your time. For everyone that's joined, I will be able to send out a copy of the recording of the webinar and also a copy of the slides, which have got Verity and Peter's details on. So if anyone wants to get in touch with them, you can do so. Otherwise, thank you very much for joining us. Thank you both for your time, and have a good rest of your day.
Thank you.
Okay,
Thanks,
bye.
guys.